Let's take you now to outside the Pietermaritzburg High Court. And Ayanda, what's the latest from your side?
Very good morning to Desiree and our viewers. Once again, the court has taken a short break after about an hour and a half of arguments by Advocate Mhlongo representing former President Jacob Zuma. As we know today, of course, that the former president has filed for a leave to appeal the Pietermaritzburg High Court ruling, which dismissed his application where he sought the recusal of the state prosecutor in his corruption case, Advocate Billy Downer. So Advocate Mhlongo, they're taking the court through the arguments as to why they feel that this judgment by Judge Pietermaritzburg, the presiding judge in this matter, should be reviewed. Let me just bring in our legal expert, to take us through what was discussed in court and some of the points that were raised by Advocate Mhlongo. Getting a bit complex at times. That isn't an easy matter to follow, and particularly when the whole issue centers around certain sections of the Criminal Procedure Act, and mostly being this title, no title to prosecute, which former President Jacob Zuma says that Advocate Billy Downer does not have the title to prosecute. I'm going to come back to start with the end of Advocate Mhlongo's arguments there, Mr. Zigalala, where he said to the judge and felt that in his argument saying that the judge had erred in his judgment. In particular, you were saying earlier on, speaking about the timing of this application. The state had said it was brought at the wrong time, it was premature. The judge also, in his judgment, had said that the matter should not have been brought at this stage of the case. However, Advocate Mhlongo now coming and saying, but Judge Pietermaritzburg is the trial judge, and in essence, we are already in the trial, and so disputing that argument by the state that it was premature for him to have brought this application at this stage.
Basically saying prevention is better than cure. We want to prevent the contravention of the Section 35 rights of the former president. So in order for us to do that, let's deal with all the preliminary issues now and all the other elements or cause for complaints that may be there by allowing former president to appeal this particular judgment. He certainly then goes back and says, let me remind you, Judge, you have inherent jurisdiction, meaning that yes, there may be legislation that tells you how you should conduct your proceedings. However, the interest of justice and what must be right according to the eyes of the law is of utmost importance. And in this case, we are saying, as the representative of the former president, allow us to go to the appeal court. The rights which are going to be contravened are far more larger than the privileges that may be suffered by the state. We have complied with everything that we needed to comply with. All that we need to do is to go to the next court that may be able to find in our favor. Let's not make this matter a moot matter. By the time the trial has started and ended, it is not going to matter anymore as to whether the title to prosecute was there or not. So in order for us to deal with this issue while it is live, allow us to go to the appeal court, and then the appeal court will be able to determine whether we are correct or not.
Mr. Zagala, in your legal opinion, and of course we're still waiting for the state to respond to the arguments or the points that have been raised by former President Jacob Zuma's defense, but one of the points was that the state, and we heard earlier on from the NPA spokesperson, Advocate Mhlongo, the state feels that this application does not apply to a special plea. In your opinion and knowledge, explain that point and why the state is saying, well, this application or leave to appeal the judgment should not happen. It does not apply to a special plea.
I would tend to differ a bit as to a special plea. Let's remember, the title to prosecute, ordinarily, it's purely administrative or mostly administrative, where one would say, you know, the person who is prosecuting me in this court today does not have the proper title. They haven't been given permission by the NPA to prosecute. So let me not waste my time in terms of arguing and providing a defense at the end of the day, which is going to lead to a defective matter. However, what the former president's team is seeking to do, they want to widen the interpretation of no charge to prosecute by saying, let's not limit it to an administrative compliance issue. Let's extend it to the conduct of the prosecutor, where we say, due to the conduct of the prosecutor, they've rendered themselves, or they've stripped themselves of the title to prosecute, as they are so entrenched into the merits of the matter. They're not being objective anymore. It's as if it's a personal vendetta rather than a duty in which they're supposed to do as per the NPA Act. So in that interpretation, I think the former president's team is trying to say, it can't be that you're not allowing us to traverse this particular point or our line of argument, especially because you're bound by the decision of the SCA. So if you want to extend that particular narrative, allow us to go to the SCA. The SCA will probably say, if it doesn't see with us or does not agree with us, let's go to the Concord. And it is actually the Concord that will come to a decision which may favor us. What is of utmost importance here is the protection of these rights as per Section 25. Then the question is, are you willing to compromise them for the fact or for the reasons that you want to get on with the trial? In fact, when you have an opportunity of protecting them at all costs by simply delaying the start of the trial so that you're able to traverse this particular issue, come to a formal decision-making process and provide a clear picture of what exactly does the meaning of no title to prosecute mean in instances where the conduct of the prosecutor may have sort of passed the Rubicon of how a prosecutor should conduct themselves.
Speaking of prosecutorial misconduct, as you say there, interesting that was the point of which Advocate Mpofu started his arguments today, starting on issues around procedure, where there's a matter relating to new evidence that the former president wanted to bring before this court, and this is in relation to the the case that he opened against Advocate Billy Downer for allegedly leaking to the media certain parts of the former president's medical report. There's the issue there about the affidavit, whether or not former President Jacob Zuma should have submitted an affidavit with this new evidence. And if I get it correctly, it seems that his defense team feels that it's not procedural.
Well, there are two ways of providing evidence within a court setting. It's either you say, we are going to put you in the witness box, you'll be able to provide viva voce evidence, or the safest option and the most expeditious one is when you have a written affidavit. In this instance, I think an affidavit would have sufficed in order to say, we are going to supplement what we had written earlier. There are new facts that have come to light, which are very important at the end of the day, that will assist this court in terms of coming to a decision. Hence, we want to submit this particular new affidavit or supplementary affidavit so that when you take your decision, you've considered it at the end of the day. Now, to come at this stage and then say, well, it's still going to go in, it's just that the manner in which we want to bring it in is not the usual manner, or we want the person in question to go into the witness box, is certainly something in which the court may frown on and say, what is the reason for you not bringing this matter expeditiously? What's the reason for you for not drafting an affidavit and making sure that you are able to provide this information, and so that it is within my disposal when I make this particular decision? You are coming at this late stage and you want to introduce new evidence as if it may be seen as if you are starting a trial day over from scratch. So in order for us to be quick in what you are doing, time is not against us. Rather, if an affidavit was submitted, maybe in that instances I would have taken that into consideration. However, from a tactic point of view, it may have helped the former president if an affidavit was there, because once affidavit has been read, you've already imprinted a certain perception or sort of influenced the mind of the judge, in which you would then say, the injustices which are going to take place if I don't agree with this particular factor that may be great. I want to protect the interest of the accused. I want to protect the integrity of the justice system, and I want to make sure that justice is achieved generally. So no matter how late that particular affidavit may be, however, if the information which is contained within that affidavit, it is so crucial and important, let me take it in, let me listen to what you have to say, so that at the end of the day, we are able to move with this trial in the most fairest manner possible.
Speaking about fairness of this matter, Advocate Mpofu actually spent some time dealing with what he felt was the treatment that the former president had been given, that he's been treated differently in this matter. From your view, you followed the case since 2018 and even way back. Whenever the former president has filed an application, the courts have given him an audience. Do you feel that he has been somewhat treated differently from any other accused person?
We wouldn't know the timelines which they are allocated within the background of the whole process. However, from what we have seen,
all right. I apologize. I'm going to stop you there, Mpumela Zigalala. The court has